Today I want to talk to you all about the recent report that has just come out from the Public Law Working Group and let you all know the top 3 points to take into account in your practice going forward. Firstly, the report has identified that there is a potential misuse of care orders. And what I mean by that is that it highlighted a trend that care orders have been made for a child who is then placed at home with their parents. Now, it doesn't necessarily mean that they are not possible. The report has highlighted that it is an exceptional option, and a care order should be used for the primary purpose of protecting a child who is suffering or is at risk of suffering significant harm, rather than be used as a vehicle for additional local authority support and services. And what we would say on this is that there is going to be a need to keep a close eye on how this policy develops in Liverpool. I know that myself and Lisa have already seen one circuit judge in Liverpool who has cited this on a few occasions. So it remains to be seen whether this will be considered across the judiciary in the Northwest. Turning to the second takeaway I want to talk about is the report highlighting an overuse of expert evidence with a high number of Part 25 applications for ISWs, psychologists, etc. And the working group are making it clear that there should be an expectation that social workers and guardians have the necessary expertise to make professional judgments and assessments. And therefore, the working group underlines that Part 25 applications should only be granted if they are necessary. Now, it's inevitable that expert evidence incurs delay. And the observation I would like you all to take away is that when considering the fact that we are now in an era where judges are following the President of the Family Division's guidance in the road ahead on how court time should be managed, we need to ensure that we are providing very robust arguments in applications on why a Part 25 instruction is necessary for our clients. And finally, turning to the third takeaway from the report, and this is probably more relevant to those of you who do advocacy in their practice, the report has set out guidance on the necessity of fact-finding hearings and a growing trend that we have cases at the moment where findings are being sought which actually don't really assist the ultimate issue for the court of deciding what is in the child's best interests from a welfare perspective. The working group has highlighted that it should be very rare for more than 6 issues to be relevant. And it is this guidance that I'm going to suggest on fact-finding hearings that actually really applies equally to both public and private family law. And the reasoning behind this guidance is linked closely to the guidance set out in the road ahead, which has directed a radical reduction in the time that the court affords to determine the ultimate issue in the case. And the observation we at UNIT would like to make is that time is by far the most precious commodity for the courts. And every judge has this in their mind in every hearing. So it will go a long way in practice to develop that very solid, robust analysis as to why those findings that are being sought can be justified.